This is a lecture for my professional responsibility class. We're going to be talking about Rule 1.13. This is part 3 of our series on Model Rule 1.13. And we're going to finish it up. We have a couple of last subsections of the rule to talk about. F, Rule 1.13F. In dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably knows that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. So what are we talking about here? We're talking about you represent an entity, again, an organization or a corporation, and there's a lot of employees or contractors and managers and directors or shareholders and owners of the part owners of the of this entity, and that you may have interactions with. And some of them may actually have interests that are adverse to your client. And remember, your client is the entity. So imagine you have a situation where you're in-house counsel for a corporation and an employee comes and talks to you about a problem that they've experienced with sexual harassment at the workplace or some other sort of workplace discrimination. And you realize when you listen to the story that this is likely to generate litigation. You need to explain to the person, I'm not your client. The entity is I represent the entity. I don't represent you, so that they don't keep going, because the constituents are not your client. And this could be true of top managers, CEOs, and presidents, and it could be the lower level employees who maybe are talking to you because you're the only lawyer that they know, and you need to explain, I'm not your lawyer. Comment 10 elaborates on this. There are times when the organization's interests may be or become adverse to those of one or more of its constituents. And in some circumstances, the lawyer should advise any constituent whose interests the lawyer finds adverse to that of the organization of the conflict or potential conflict of interest, that the lawyer cannot represent such a constituent, and that such a person may wish to obtain independent representation. So again, if you represent an entity, and this could be a for-profit corporation, it could be a large nonprofit like a university or a big hospital complex or a school district or something like that, and you could be in-house counsel or outside counsel, and someone talks to you about a workplace accident or a workplace altercation, or explain something that you realize is going to be embezzlement, counts as embezzlement from the company or is illegal, and you now have an affirmative duty to explain to this constituent, wait a second, I'm not your lawyer. Just make sure you understand, I'm not your lawyer. I represent the entity, and your legal interests in the entities are at odds here, and I have to be on the entity's side. A lot of times, non-lawyers will assume that you're neutral or that you're on their side too because you represent their employer. And this brings us back to a case we talked about earlier in the course about the Coca-Cola truck driver who had a tragic accident with a school bus full of school kids here in Texas several years ago. And it was a really awful tragedy. The school bus was sent kind of flying off of an overpass. A lot of the kids in the bus died, and many others were seriously injured. We talked about this earlier because there was some controversy about the fees that the plaintiff's lawyers got. They got when there was a large settlement that occurred right away before trial. And I mentioned at the time we were going to come back to this case, and now we're going to talk about Coca-Cola's lawyers, the defense counsel. Because what happened is the truck driver for Coca-Cola survived the accident, and he was injured and he was in the hospital. And lawyers for his employer, Coca-Cola, went and visited him in the hospital, didn't explain to him that they were not representing him. So they identified as, hi, we're lawyers from corporate, or we're lawyers for Coca-Cola, your employer. And he admitted to them in the conversation that he was intoxicated, either high or drunk while he was driving. And they, at no point in the conversation, informed him, by the way, we're not your lawyers. So think about it. If you're for my students, they have a duty to their own client. The client is the entity, Coca-Cola, to inform their client, look, this driver was intoxicated and was violating corporate rules, was acting outside the scope of his authority. And so this actually might be a way for them to escape liability by casting all the blame and responsibility on the driver himself. And so this is wrong. This is what the rule is talking about, that when we're dealing with a constituent, like an unsophisticated employee, that the lawyers have a duty to explain, be careful, I'm not your lawyer, right? Don't keep talking, I'm not your lawyer. And so, in fact, comment 10 continues, care must be taken to assure that the individual understands that. So don't sit there thinking that, wow, this is really a problem. This is kind of funny, they don't get it. You have a duty to make sure that they understand when it looks like there's an adversity of interest, whether litigation is pending between this constituent yet or not. The lawyer for the organization cannot provide legal representation for that constituent, and that discussions between the lawyer for the organization and the individual may not be privileged. Now, G kind of goes along with F, and this says that, bottom line, it is okay, permissible, but not automatic, that you would represent a constituent and the entity. So just to make sure you understand, the default rule is F, where the entity is your client, not a constituent. But sometimes the entity client, the organization, actually wants you to represent their CEO who's listed as a co-defendant, let's say, or their employee who's listed as a co-defendant. So G says a lawyer representing an organization may also represent any of its directors, officers, employees, members, shareholders, or other constituents, subject to the provisions of Rule 1.7. So that's our conflicts of interest rule. And remember, obviously, you could have a situation where eventually the two are going to become hostile or file a cross-claim, or one wants to be indemnified by the other, or one is going to testify in a way that makes the other look like they have a bigger share of the responsibility. G continues, 1.13 G continues. If the organization's consent to the dual representation is required by Rule 1.7, so remember, Rule 1.7 normally requires informed consent confirmed in writing from the clients if you're going to proceed with the representation in spite of having some sort of conflict of interest. The consent shall be given by an appropriate official of the organization other than the individual who is to be represented, or by the shareholders. And so I hope this is obvious. So let's say you have a president of a corporation like Mr. Burns in The Simpsons or something like that, who's being sued as a co-defendant with a corporate entity. Now, that executive can give consent on his behalf or her behalf to the conflict of interest, but it can't be the same person who consents on behalf of the entity as a client to the conflict. In other words, it doesn't make any sense that we would have one person consenting on behalf of themselves and another client to a conflict of interest. Find someone else from the board of directors, a representative of the shareholders or something like that, who is going to be able to provide informed consent to the conflict of interest. And that concludes our lectures on Model Rule 1.13 or 1.13.